crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. A really interesting topic of conversation tonight and a great panel all here for you to deal with legal matters that we believe are of interest and matter to you and your life. The next half hour, that's what is going to unfold. A couple of ground rules in case you're new with us. First of all, welcome. And second of all, you'll see at the bottom of your screen all the ways you can get in touch with us, and we'd love to hear from you. Also, Hollis Wright makes available attorneys who are standing by live all throughout the program tonight some free, confidential, and off-air legal advice at 844-LAW-TALK, 844-LAW-TALK. You might want to take advantage of that during the program tonight. Leading our conversation is the managing partner of Hollis Wright, Josh Wright. Good to see you, my friend. How are you?
Well, I'm doing great, doing great. Good. You know, David, just about everything that we do involves some level of insurance, whether it's homeowners coverage, whether it's automobile insurance, whether it's life insurance, whether there's a personal injury case and there's insurance involved or a defense involved. It involves insurance. Right. And one of the things we're going to be talking about today, we're really lucky to have a true expert on today. Sometimes we have kind of experts. We got a true expert on today. But we're going to be talking about bad faith and kind of how to manage litigation to make sure that the insurance company is doing the right thing. Okay. My good friend, your good friend, Tom Sinclair, who's been on the show before, is with us today. Wow. And you are a legend in the area that we're going to be talking about, and I'm super happy to have you on.
I should get up and leave now.
That's it.
That's as good
if
as
everyone
it's
introduced you like that daily, you'd be good to go.
I love that. Here's the truth of the matter. I have worked with your firm for a long time now. Yep. And I can tell you that the key to finding someone that you need to serve as your intermediary sits right with this man right here. The truth is that this show is so important to the public because it's your opportunity, your chance to get in touch with somebody who works on your side. When we talk about these insurance products and these safety net items, we're talking about the cases that you handle every day and the lawyers at your firm handle every day. From my perspective, when you get a lawyer with a motor vehicle accident, with a workplace injury, with a medical malpractice claim, if you've been hit by an 18-wheeler, if you've had some illness that has taken you out of work, the first call you ought to make is the call to this gentleman right here and the lawyers at his firm, because they're going to put you in touch with everybody at their firm that they have that specializes in these areas. And if they need to, they can reach out to me. I know you got experts sitting right there.
By the way, I'm going to get up now and just walk out, and that's going to be the end of the show.
Turn it over.
Ladies and gentlemen, what that guy said.
Listen, the truth is, at this show, and that phone number is so important because it's your chance to reach out and get in touch with a lawyer to work with you. If you're going to find yourself relying upon your safety net, if you're dealing with an insurance company after a car crash, or if you're dealing with a workers' comp carrier, if you're dealing with a disability claim, you need somebody working for you because, trust me, the insurance companies have hundreds of people working for them. That phone number is the first thing you ought to go to. You ought to write it down now, and you ought to put it away. Even if you don't need it today, someday, God forbid, you might. And that's the first call you should make.
Well, that's very kind, and I appreciate that. Tell us a little bit about this concept of bad faith, because, you know, I introed the show with just about everything we do as a firm involves insurance, and I know that you're part of that process too, but you're evaluating a lot of times the decisions made by the insurance companies to make sure they're not engaged in bad faith. They are doing what they're supposed to do. They're maintaining their obligations and duties under the law, and if they don't, there's someone to protect that individual because they didn't. And so how did you get into this area of the law? And let's just kind of unwrap this a little bit.
So when we talk about bad faith, we're talking about Alabama state law. And bad faith is a situation where the insurance company has tried or has denied your claim, and they've done so under one or two recognized categories of bad faith. You have normal bad faith. Think of this as the situation where everybody in the courtroom, from the judge to the jury to even the lawyers on every side will look at it and go, they didn't have a real debatable reason to deny this claim. And then we have what's called abnormal bad faith in Alabama. And that's where they engage in willful blindness. And that's a special type of situation where you have an insurance adjuster or an insurance company who has willfully blinded themselves to the tragedy that has brought you to their doorstep. In Alabama, we recognize the importance of insurance for the simple reason that these claims are filed in times of crisis. Yeah. I mean, how many times have you seen somebody come in after a horrible car crash? They can't go to work. They have lost their means of transportation. They have no income coming in for their family. They can't put food on the table, and there's a claim filed that's been denied. Yeah. I mean, look, insurance companies are held to a higher standard because that's the standard they promised when they sold us to that product. Bad faith holds them accountable. Bad faith is the key here because without it, all they're going to end up doing is paying you what they should have. That's ERISA. That's a different kind of category of claim that governs your employee benefits. ERISA is not good. ERISA is bad. But half of Alabamians end up with insurance through their workplace. So the key is reach out to the lawyers, get the lawyers digging into it. It's not just calling them up and going, I had a car crash, because the lawyer on the other side of that phone is going to look into what safety net products do you have in place? Where are you going to work? Yeah. Where are you transporting something for work? These are the things that you need investigated, and that's why you call these lawyers at Hollis.
Yeah,
Wright.
you know, and the reality is, David, that insurance companies have a whole host of reasons why they would deny claims, fail to investigate claims, or really just kind of be standoffish when someone's in a time of crisis. And there are a lot of things that we see, and sometimes it's just that, you know, they've made a judgment call as a group that we're going to deny every single claim until someone pushes us. And what Tom's talking about is exactly right, that if the only thing that they're held to is ultimately having to pay that claim, that is not a tremendous incentive for them not to do the right thing. Mm-hmm. Instead, bad faith, and what we're talking about today, has its own potential monetary exposure and damages to the insurance company that protects individuals in their time of crisis, and gives an extra option to punish that insurance company in a way to make sure they're doing the right thing, they're properly investigating, they're properly paying these claims. So it's super important.
Let's take a break right here. But whenever we come back, let's get into some of the types of cases that deal with here and have to where bad faith comes into play. We'll do that after the break. First, though, reminder: you're going to want to check out Hollis Wright on social media. Wherever you are, they are, and it's a very helpful, informative, educational resource that you're going to want to have there at your ready. They're on Instagram, YouTube, Facebook. Again, everywhere you are, Hollis Wright is there. So check them out on social media. Stay tuned. We are coming right back with more of The Attorney.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, That's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back in to the attorneys. Before we return to our conversation, a reminder, the attorneys from Hollis, Wright standing by live to speak with you. 844-LAW-TALK, 844-LAW-TALK. Go ahead and give them a call. Josh?
Or you can text and email, and we're going to respond to you, which is good. We got real experts answering questions tonight. All right, so Tom, let's talk just generally, because we unwrapped that package of bad faith a little bit in the first segment.
Yeah.
Explain some real-world examples of where this shows itself and manifests itself.
You know, really where it comes in is something called damages. When I look at a case, I think about broadly two different things. I think about liability. Who's responsible for this injury? Who's responsible for not paying this claim? And then I look at damages. Now, there is a special category of safety net items, life insurance, disability, all these products you get through your employer. That's governed by ERISA. That's a special law, the Employer Retirement Income Security Act. We handle those claims. But really, those claims, all you really get is what they should have paid to begin with. When you talk about bad faith, though, when you talk about bad faith, you're talking about an opportunity to be made whole, to get the emotional distress damages that you're entitled to under the law, get the contract value of what they should have paid you to begin with. Not just the futures, but the past dues as well, the whole bundle. When they've abandoned their obligations to you, that's what comes up. You can be made whole, and then we can talk about what is typically for juries a shorthand of a multiplier of that compensatory damage category. Really what we're talking about doing when we talk about bad faith is we're talking about deterring. We don't want insurance companies getting away with treating one insured as badly as I've seen in a lot of cases, because if they do, if they can make money doing it, they're going to keep doing it.
Yeah.
And that's what the law is designed to prevent. We're not going to let them get away with it over and over and over again, and we're going to hold them to account.
Yeah.
You've got to have somebody on your team to do that. I know a lot of you are going to think, I can handle this myself. The truth is, when we talk about bad faith, you've got to take away their debatable reason. You've got to take away and drag them out into the sunlight so they can't hide behind that claim file. Really, if you're going to talk about bad faith, your trial may be going on while the claim is open before you even file the complaint, because that's when you can take away their debatable reason.
Yeah.
That's what's so important in all these cases. People get correspondence from insurance companies all the time. You've been in a car crash. You've been injured at work. You don't want to go hire somebody, so you just think, I'll sign this document. And that document gives away your rights, creates a debatable reason for them. These damage categories, they're crucial. That's the key to bad faith.
Yeah.
Make it economically unviable for them to deny claims that they should be paying.
Yeah, what I see, David, more than anything is there's some really good adjusters out there that Tom and I deal with on a daily basis that don't engage in bad faith, that will resolve claims for real value or be respectful enough to recognize that there are some claims that have to be litigated, depositions have to be taken, things have to happen in order to properly and fully and completely investigate the claim. What I see, though, a lot is adjusters that are what I call results-based analysis adjusters. That is, from the start, they see the result they want. They want this to be a non-covered claim, and they dig their heels in, and they stick with that, and that is their result, and they're going to find a way to manufacture the evidence to make sure that the result that they want happens. That is the worst scenario, where you've got to have someone like Tom, or you got to have a lawyer involved that can lead, guide, and direct you through that process to make sure that the results-based analysis adjuster is held accountable for bad faith.
Tom touched on something that I think most folks can relate to, and that is that most folks try to handle it as much as they can on their own. try not to, do what they can. And oftentimes that gets us into trouble. I happen to be good friends with some good lawyers. My wife and I have a couple of businesses. You remember this. We had a situation with the building that the landlord said was fine. Don't worry about it. We've got it under control. And it just kept getting worse. And I called you and I said, hey, this just doesn't feel right. What do you think I should do? And so Josh referred me to an attorney in the town where this happened. But it was like a gut thing where I didn't really have a case then, and I didn't know what, you don't know what the future holds. Are there any hints as to when it's just a good idea to reach out to somebody and say, hey, can you help me with this?
It's a good question.
Look, I have seen so many times that people did not listen to their gut. Listen to your gut. When the argument starts, that's the tip of the iceberg you've just spotted. It's not the entirety of what you're going to have to deal with. When they start arguing with you, when they start trying to diminish your claim, when they start talking about paying less than you feel is fair, listen to your gut. Do not believe the other side of this is going to behave in a way that is fair and just without some oversight. Now listen, Josh just said something crucial, and I want to make sure that you all heard what he was talking about here. Some adjusters behave fairly. We don't paint everybody with the same brush, but we've seen some repeat actors. And here's the other side of that coin. When you have a law firm that has dealt with those companies over and over and over again, those companies, those adjusters know, those lawyers are not going to let me get off easy here. Those lawyers are going to hold me to account. Maybe I can save the company money in this other claim, but not if I've got the Hollis Wright crew on there. That's the key. Get somebody on your team that knows that company, that knows that adjuster, that knows those claims. Get them on your team and working hard, because what you'll find is that their involvement, their experience adds value. This is crucial. Don't think you can get away with getting the most out of your case by yourself. You need somebody with this kind of experience.
Yeah, there are statistics out there that I truly have accepted in my practice, that insurance companies are going to offer individuals without lawyers a third of the value that they would offer if you had a lawyer. And so I think that there's an opportunity to get a lawyer involved early so that that lawyer can not only increase value, as Tom's talking about, in the claim, but make sure the insurance company is properly evaluating all potential damages, all potential issues that are applicable in the case, to make sure you're fully and completely compensated. And if you do your job by getting a lawyer involved early enough, they can pay for themselves through an increased value of the case. And that's kind of what Tom is alluding to there. But it only is going to happen if you hold that insurance company accountable to make sure the person's properly and fully compensated. I'll give you one quick example. I know we're about to go to break, but another quick example is sometimes insurance companies may not want to evaluate a lost wage component, may not want to evaluate a permanent injury component, because we believe you can get a permanent injury jury charge if the case actually goes to trial. Those components have to be weighed to make sure the full value of the claim is compensated by the carrier. And if you don't have a lawyer, you don't know to do those things. And so I think getting a lawyer involved early is important.
And I'll just tell you, Sonia, my wife, and I slept a whole lot better knowing somebody was looking out for us.
Yes.
We weren't just facing it on our own. Yep. At least we, had somebody looking out for our interests. Which,
peace of mind.
Peace of mind, exactly. And it's hard to put a price on that as well. All right.
When we come back, we're going to talk about how you work one of these claims up, and we're going to let Tom talk a little bit about how you work a bad faith claim up and why you get a lawyer that can help you work the claim up. And if you don't have a lawyer, you may not be able to have a bad faith
All right,
claim.
we're taking our final break of the evening, so the clock is ticking. Join us to get involved. Stay tuned. More of the attorneys coming right up.
I'm attorney Carter Clay with Hollis Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. The final segment is upon us, just under 6 minutes remaining in the show. So if you want to take advantage of that opportunity to get in touch with attorneys from Hollis Wright, 844 Law Talk, you got about 6 minutes to do so. Josh?
Now, Tom, I've heard, and I think you have preached to me before, the importance of really working up a bad faith case before you even file that case and strategically doing it. Yes. Explain that a little bit, because I think it's super important for people to realize why they've got to get to a lawyer like you to handle this kind of stuff.
Okay, so this is going to be important both for your employee benefits governed by ERISA and for your bad faith claims, individual insurance products you purchased outside your employment. When it comes to that claim file, I want you to think of the claim file as a shield they are creating. That's what the insurance company does. They go in there and instead of collecting 20 years worth of history for your failed back syndrome and a disability claim, they only get 3 office visits and put it in the claim file. They don't investigate to see whether or not that 18-wheeler had driven beyond what the Department of Transportation said they should and are driving in a wrong or negligent manner. They're not going to put in that claim file the things that have led you to file a claim that are favorable to you. Instead, they're going to be doing it for themselves. They're going to create a shield. That claim file is their shield. What you need to do right now is start working that claim file from your side. And you only do that with a lawyer. At our firm, we take every document that we get from an insurance company, we Bates number it. Before we ever get to a lawsuit, we send it back, say this is what you sent. We Federal Express documents to them so we can prove they got them. The Bates number documents, we can show they had them. We take their shield away from them. We make them stand in the sunlight. Listen, all of us have occasionally done something we're a little ashamed of. That's the way we are. We're human. But if you get the wrong kind of claims handler on the other side, that's somebody who wakes up every morning, looks themselves in the mirror, and thinks, I'm going to do whatever I can to get my bonus. I'm going to do whatever I can to get my quota of certain claims denied. I'm going to do whatever I can to keep you from getting the benefit of what you paid for in that safety net. You've got to have a lawyer working in that claim before you get to court. That's crucial, because that's how you take away that debatable reason. They get rid of their shield, everybody stands in the sunlight, and all of a sudden you've got them in front of a jury, and that's when the truth comes out.
When you file a bad faith claim, do you have access to the full extent of the claim file in the bad faith claim? Because a lot of times in a non-bad faith case, you're never going to see the claim file. How does that open up in litigation for you to be able to prove what you're talking about from a bad faith perspective?
This is crucial, and it goes back to what you were saying earlier, Josh. Experience matters. Experience with these companies matters. I know Josh and I both probably have massive libraries on particular carriers and the way that they do things. We go into discovery and we fight those battles. We take those depositions. We fight over the papers. We don't take their word for things. We operate in a trust but verify state constantly. We didn't know that happened to Mrs. X. Then we get in there, we get their emails, we get their text messages, we find out what they did behind the scenes. They will give you a set of documents to say, this is your claim file. Well, thank you for doing that, but now we're going to go and we're going to find what I want.
Claim file.
Bingo. And you get that with experience. If you don't have experience dealing with these cases, if you don't have a set of lawyers that you can call, that's what this show's all about. Yeah. It's crucial to have that.
Less than 2 minutes remaining. Time enough just for a final thought from the both of you. And Tom, if you would, you go first, please, sir.
Listen, it's the 7th Amendment. Over and over again, I preach this. A jury of your peers, the 7th Amendment. You have a right to a jury trial in a bad faith case. Take it. It takes a while. In the Northern District of Alabama, it could take 2.5, 3 years. The federal courts in Alabama, it could take 2 to 3 years to get there. So few cases get there. 2 out of 1,000, 3 out of 1,000 actually get to a jury trial. That means if you've got the right lawyers, maybe they got you a good settlement. They got this case resolved early. But it also means you have a right to a jury trial guaranteed by the Constitution of these United States. Don't be afraid of the courthouse. That judge in a robe with a gavel, that judge has got power because you gave them power. Don't be afraid of courthouses. They are your places to resolve.
Yeah, and the Constitution is one protection people have. Bad faith is another protection that they have to make sure that they are able to, through counsel, get the full value of their claim evaluated correctly, assessed correctly, and then resolved correctly. And if you don't, you want to be with a lawyer that's going to go try that case for you, that says, look, this just isn't fair value. We're going to try that case. And those are multiple types of protections that you have, the Constitution and then the law with bad faith. So we're just happy to have Tom on to be able to talk about that. Great job.
Always a pleasure.
Absolutely.
Awesome. Really good stuff. Appreciate you guys being with us and you as well. Thanks so much. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.